Before we discuss the current right-to-know law, a statute designed to ensure that legal residents of the United States have access to records of their government in Pennsylvania, I want to discuss the history of accessing records in the Commonwealth of Pennsylvania. Prior to 1957, courts recognized a common law right to access public records. Based on the lack of an explicit statutory underpinning, the common law right of access, however, was not consistently applied. Some courts, for example, held that individuals only had a common law right to access records where a personal or property interest could be demonstrated. Other courts held that all citizens possessed a common law right of accessing governmental records, regardless of a particular interest. As the Pennsylvania Supreme Court aptly noted in 1958, prior to the enactment of the 1957 statute, the right of a citizen to the examination and inspection of public records was the subject of some confusion. In 1957, the Right to Know Act was enacted, which, with respect to records held by legislative agencies and non-judicial agencies, supplanted the common law right of access to records. The Right to Know Act, as amended by Act 9 of 1971, featured a limited definition of public records as essentially an account, voucher, or contract. Under the Right to Know Act, requesters bore the burden of proving that records were considered public records. Once a requester proved that a record constituted a public record, an agency bore the burden of demonstrating that the record was not subject to public access. Courts often referred to this process as a balancing test, requiring courts to weigh competing interests. Prior to 2002, requesters seeking to challenge an agency's decision to withhold access to records could only do so by appealing directly to court. Under the 2002 amendments to the Right to Know Act, requesters could appeal to the head of an agency before seeking judicial review. If the request involved a Commonwealth agency, a requester had to first appeal to the head of an agency prior to seeking judicial review. Under the 2002 amendments as written, if a request involved a non-Commonwealth agency, a requester had 3 appeal options. 1. The requester could choose to appeal to the agency head. 2. The requester could appeal directly to a county court of common pleas. Or 3. The requester could appeal to a magisterial district. On December 12, 2002, the Pennsylvania Supreme Court issued a per curiam order assigning all appeals that could be made to a magisterial district under 65 PS, Section 66.4b, solely to county courts of common pleas.